All right. Well, good morning, everybody. Everybody shake it off. I know we're dealing with a lot of really exciting things here. The good news is a lot of this might go over your head. And the good news is we're here to know all this for you. We're just kind of giving you this overview so that you can get a little more familiar with these terms so that when we have our discussions now in the future, you're more educated. My portion is going to touch on a few things that have already been touched on, but then I'm going to get to what's probably the most exciting thing for you, is to quote Jerry Maguire, show me the money, right? So when we get these claims on file, you're probably wondering, how much can I expect to get in return? The short answer is, we don't know. There's no magical formula, but there are a lot of guidelines. So I'm going to get into some of those. But before that, like I said, let me touch on a few different topics here because they all play into how the court determines how much your case is worth. So already you've heard the terms on-table and off-table claims. And Jonathan already showed you there's a literal table that here we go. There's a literal table here that is in the vaccine program with 3 different columns. In this first column here, it shows the vaccines that are covered. I'm not sure if it was said before, but the vaccine program only covers a certain list of vaccines. So if you get something else that's not on that list, you cannot have a claim in the program, okay? The second part of this table, you don't have to have one of these injuries, but if you are an on-table case, it means you have one of the injuries that are listed on this table that were associated with the vaccine that's in the first column. So for here, we have various tetanus vaccines, and then there's 4 conditions that the program recognizes that can be associated illnesses, disabilities, or injuries that are associated with that vaccine. We have anaphylaxis, brachial neuritis, Serva injury, and vasovagal syncope. So then we have a third column, which says, if you have this condition in the second column, what is the typical time that you're going to see your first symptoms? So I'm going to jump right down to this one because this is the one I'm going to specialize today, because this is the one that the majority of our clients have. And those are the shoulder injuries or the Serva injuries. So a Serva injury is usually seen equal to or less than 48 hours. So if you have the vaccine to get in the program, you have one of these injuries in the second column, and it shows up in the time frame that's shown in the third column, then that's considered a table injury. And that means you will get through this program much easier than if you were not on the table. So let's, and then I also captured the last column, which Jonathan already showed you, which has that last category showing just a catch-all saying, any new vaccine recommended by the Centers for Disease Control and Prevention for routine administration to children after publication by the Secretary of a notice of coverage. So this is what Jonathan was talking about, where we hope that this happens with the COVID vaccine so that it gets added in here. And then these 2, at least these 2 injuries would be covered, the shoulder injury and vasovagal syncope. So what is a Serva injury? Serva is an acronym for shoulder injury related to a vaccine administration. Now in the statute, what that explains is it manifests as shoulder pain and a limitation in your rotation, your rotation. It's presumed to result from the unintended injection of the vaccine antigen or a trauma from the needle into or around the area of the bursa in your shoulder, okay? And it results in an inflammatory reaction where there's a lot of inflammation going in there. There can also be injury to the musculoskeletal structures, such as the tendons, the ligaments, or the bursa, but it is not a neurological injury. Don't ask me why. I have clients that have neurological injuries that were the result in their shoulder of this vaccine, but for some reason, it doesn't fall under this umbrella definition. So then I'm going to talk about something called the special processing unit. That big, long procedure for getting through this, the program that Patrick touched on is expedited if your case gets diverted into something called the Special Processing Unit. It was originated in an attempt to streamline and expedite the processing of certain claims. The claims that it covers or it usually takes on are ones that are without substantial complicating factors that have historically been conceded or settled. And that includes especially table injuries. So they touched on the fact that there's a presumption that the vaccine caused your injury if you fall into the table. That's why those tend to go to the Special Processing Unit. Just as an aside, some things that might not get into the Special Processing Unit is if they found out that you had already had a long history of shoulder injuries, and there's other complicating factors around that. But in general, table injuries do go into the program. And here's a statistic that was produced in September of 2020. It showed in 2020, about 75% of all claims were assigned to the SPU, the Special Processing Unit. So that's good. They're trying to get as many of the claims in this unit. The unit was created in 2014 for the purposes of getting them through the system a little quicker. Okay, so now let's just break it down. So once you get that petition on file and you're part of their system, the vaccine cases go through the process in two phases. The first phase is the entitlement phase. So it's being determined whether you're entitled to any compensation at all. Was your injury an injury that was caused by the vaccine? Once you've gone through that entitlement phase, then it goes to the second phase of the case. So if the first phase of the case, they said, yes, you're entitled to it, boom, you get damages. Then the second part of the case is how much damages. And you assess how much damages by receipts, by settlement discussions. Now, a settlement is something that can happen before it's determined you're entitled. So before the first phase of the case is over, or you can settle the case after that. And I'm going to show you the differences because there's a money difference. There's a money difference. If you settle it before entitlement is issued, then you're going to get a little bit less. If you try to settle it afterwards, you're going to generally get a little bit more. But in general, this has already been touched on, the amount of damages that you can get under the vaccine injury program are your past medical expenses from out of pocket, lost wages and earnings, future medical costs. It's not very often that they award those. Those are in cases where there's proven facts and usually experts showing that you are going to need some kind of substantial medical care in the future. And then pain and suffering. And as Jonathan touched on, that is the bulk of most of these awards for these shoulder injuries. Also, I want to point out that 1, 2, and 3, they're specific numbers usually. So out-of-pocket expenses, you add up your bills, it's a specific number. Lost wages, you do some calculation as to which days you were off or how many days you're going to be off in the future or how, what you earned in the future. Those are going to be specific numbers. Future medical, you usually get an expert to determine what the exact numbers are based on statistics and the going rate of things. So there's definite numbers attached in those categories, but pain and suffering is like a wild card. It's really hard to determine the pain and suffering, what amount is associated with pain and suffering. In the vaccine injury program, there's a limit to how much you can get in pain and suffering. It's set that you can only get $250,000 as the top amount that you can get. Now, there is case law that says that when they're deciding pain and suffering, they're not supposed to do it on a comparative global scale, saying, oh, we're going to compare your case to a really extreme case, and we're going to kind of do a comparative measurement from there. But the reality is that the Department of Justice and the Office of Special Masters do kind of do it on a sliding scale when it comes down to a practical matter. They're looking at some cases that involve severely injured people or children that are going to be debilitated for the rest of your life. And even though you have a terrible shoulder injury that had surgery and needed to be repaired and went through a lot of pain and suffering for a couple years, and now it still has a few little problems here and there, In regular litigation, that case very well might warrant you $250,000 of pain and suffering. But because they're saying other injuries that are really major, that's not how the verdicts and the settlements pan out. So I'm going to give you some examples of what they settle these cases for in a second. But here are some factors that they look at to determine pain and suffering. Patrick touched on this. They look at the severity of your injury, the duration of your suffering, how aware are you of your injury, and the special masters will also decide your pain and suffering based on their experience of adjudicating similar claims with similar facts in your case. They also might look at other pain and suffering awards that have been awarded in other cases that might not have been them. Okay. So now here's a chart that was issued in 2020, September 30th, 2020. Here's some average median awards by different types of injuries. And as you can see, I'm going to jump to the Serva injury, which is right here. It's number 2. So in September 30th of 2020, the median award of all the awards that were awarded for Serva in that year was $80,739. Okay. So that's one thing you can look at to try to determine what your case is worth. And then here's another. We're going to look at some settlement statistics. Before I go into that, I'm going to go over something that I already mentioned. A case can be settled before entitlement, which means there's no ruling yet that you're entitled to any damages, which means there's some degree of a litigative risk. That means that your damages aren't guaranteed at this point. So you still have a risk of losing, or you have a risk of them disputing that you're entitled to it, which would put you into a lengthy litigation process. You're also risking the fact that you don't really know what special master would ultimately be deciding your case if you can't reach an agreement, and they all have different, tendencies to be more liberal or more conservative. So there's there's some risks involved there. So that's why some people might want to settle their case before entitlement has been declared. And you'll get the award sooner rather than later if you do it earlier in the case rather than later in the case. Now, after entitlement, you're definitely entitled to damages at that point. So the amount's going to go up because your damages are guaranteed. But the bad news is you'll get it then later in the process. It'll take longer to get there. So here are some cases. These are the Serva cases. So this is just Serva, not the other injuries. The shoulder injury cases that have been in the SPU unit. There were 1,405 Serva cases that were looked at over a span of 6 years since the SPU has been formed. Of those cases, the ones that had a settlement before entitlement was determined, their median award was $70,000, okay? And if you looked at the bulk of those cases, throwing out the real low ones and throwing out the real high ones, a range would be $50,000 to $92,500. So that's the typical range of settlements that happen before entitlement. Now, of settlements that happen after entitlement, the median award was $95,000. And the range, throwing out the real small ones and throwing out the real big ones, would be roughly $75,000 to $122,000. So again, this is another thing to look at when trying to decide, should I settle now? Am I getting a fair offer at this point? Another thing to look at is those were settlements. Now these are court awards, meaning they couldn't settle the case. The case went to an actual hearing in front of a special master, and the special master decided what you were entitled to. So it's a different phase of the case, a different person deciding, and it happens toward the end of the case. So we're going to look at two different categories. We're going to look at a group of cases where the special masters awarded pain and suffering, not the full award, because remember I said the first three categories of damages are set amounts usually. The pain and suffering is the wild card. So we want to get a flavor or an idea of what the judge or what the special masters are awarding in cases. So in cases where they determine your pain and suffering is worth between $60,000 and $90,000, in that range, here's the general facts in those cases so if you have a case and you have some of these factors, you might want to look at this range, because we're going to go into a bigger range in a second. So in the cases where they awarded pain and suffering between 60 and 90,000, in general, the Serva injuries had a good prognosis in the medical records. There was some residual pain in some of the cases. Other cases, it was resolved completely. No future pain and suffering was proven or awarded. The range of motion restriction was mild to moderate, and that's established usually in the medical records. And they had MRI results, and the MRI results showed mild to moderate pathologies such as tendonitis, bursitis, or edema, which is liquid. The duration of their injuries was on an average of 14 months. So they were experiencing injuries from their shoulder injury for 14 months, but the range was usually 6 months to 29 months. Their pain was usually rated at a 6 or lower in about half the cases. That type of a pain level lasted for an average of 6 or 8 months, excuse me. And in some of the cases, their greater pain and suffering was only experienced for 3 months or less, and then it kind of went down from there. And in less than half the cases, they had 1 to 2 cortisone shots. So that's kind of a major thing to have a shot here. So in some of these cases, that actually did happen. And they had physical therapy in most cases that was 2 months, lasted 2 months or less. And in none of these cases did they have a shoulder surgery. And in about 7 of these cases, which is a little less than half, there was a delay in treatment. So the delay in treatment varied from 42 days to 6 months. And that's an important factor because, if I feel like my arm is falling off and I'm in extreme pain and I'm in tears, it's going to be presumed that you have a really bad pain and suffering and you're going to get treatment sooner rather than later. If you have bad pain, but you can really negotiate through it, or you can tape it up and kind of, get through your life without it and think it's going away, and that might delay your treatment, and they'll think that your pain and suffering is probably a little bit less than the first example. So now here are court awards where the court award for pain and suffering was in the range of 110,000 to 160,000. And that included about 8 cases. In those cases, same as before, the injuries had a good prognosis. Same as before, the other example, there was no future pain and suffering. But in this case, the limitation of their range of motion in their arm was considered moderate to severe in their medical records. The MRI results showed more significant findings, and there were more multiple findings. So there was a lot of things going on described in their MRI. In 7 of those 8 cases, one of those findings was evidence of a partial tearing of something in their arm. So that's a little bit more major, or at least it's considered a little more major in a little more painful in these court awards. And in 7 out of 8 of these cases, there was actually a surgical repair to the shoulder. I believe the 8th one, he couldn't have surgery for other reasons, but he definitely was a candidate for surgery. Also, in this range of pain and suffering, in the medical records show a pain rate of over 5 from these people. They experienced in one case, the person had a significant amount of pain that lasted 8 full months, and then an actual 2 years of pain and suffering that dragged out. In 6 of these cases, cortisone shots were administered. The physical therapy here seemed to arrange in a much higher way. They had physical therapy range was between 1 and 28 months. And like I said earlier, usually it's considered, if you're considered to have more pain and suffering, you're considered probably to go to the doctor sooner rather than later. So in these cases, they had more immediate first treatment. They got their first treatment between 5 and 45 days. So that's the end of mine. But I also want to point out, let me stop sharing. I also would like to point out that in these cases, none of these cases happened during the era of COVID. So we have been putting in our petitions and in our affidavits, paragraphs reminding the court, because this might not be decided for a year or two, that this was a period when COVID was going on with people. So what does that mean? That means maybe you didn't go out to get physical therapy because you were home taking care of yourself under the general suggestions of the health community and the government. Maybe you didn't get that first treatment sooner than later because you were, again, trying to take care of yourself. So we are very cognizant that that is a factor in a lot of our cases right now. And we're definitely going to push that so that the court does not hold that against you when they're determining their awards. The other thing I want to point out is some things, Patrick went over the evidence we looked at, because we have a lot of clients that are delaying treatment or not getting live treatment because of this COVID pandemic. I've been having clients dig into their text messages, emails to doctors. I've been, recommending, I understand you don't want to go to the doctor, see if you can get a virtual appointment, something that documents in real time that you're complaining about your shoulder injury, so that it's not your word in an affidavit, because the court's not going to hold a lot of weight for that. So that there's a third party, whether it's somebody you text, somebody you emailed, or especially your medical records from a virtual appointment, something to document that you're complaining about this injury and it's connected to this vaccine when you got the vaccine. That is all additional proof so that you fall into that table injury, and we can get it nice and neatly wrapped up for you as best we can, so that we can get you through the system as quickly as possible, and we can get you as much damages as we possibly can.